Yes.
This is the heart of this case. This is what my learned friend said, because you can't argue that there's a binding decision on the Secretary of State to establish that. So we're not in the principles of you can't look at this because you're bound by something. We're in territory where you can look at it, but you have to pass a sort of legal test. And what is that legal test? And my learned friend says it's not diva silent, it's Latin-Marsh. And he bases that on paragraph 31, which we see says that where an immigrant is entitled to ILR, in considering whether to take action that has the effect of revoking that leave, the Secretary of State must give proper attention to principles akin to those identified for the admission of fresh evidence in legal proceedings as set out in Latin-Marsh. If he does not do so, his decision is liable to be set aside on judicial review. So that is making a decision at all, as it were. If you've gone and made a decision when you didn't get over the threshold, Latin-Marsh was the threshold for sort of considering the case and making another decision, then it will be set aside on judicial review, and that is not this case. There was nothing in principle, because it's not binding, that first tier. I'm going to call it FTT1. The first tier tribunal decision one wasn't binding because the actual application had to be considered anyway, and there was no direction in it or anything in a judicial nature which said this is how you must go about this when you consider it Secretary of State. And then the next point is looked at as TB. But of course, TB is a case, as I indicated earlier, where finality of litigation was in point, paragraph 35, because there was a point that was part of the very question in relation to TB and his status in the UK that could and should have been litigated at the beginning. So it was all part of that question. So the mischief there, the abuse there that was being relied on was essentially the Secretary of State allowing half litigation, if that's the way of putting it. Half litigation, half the question to be considered without raising the other bit of the question. And then when you fail on the half of the question, you say, but there's this other bit of the question, and you ask for that to be litigated. And that's definitely not this case. So the whole case could have been put, paragraph 32, the whole case could have been put at the outset, but the Secretary of State didn't put the whole case. So that's a second bite at the cherry, because you've only made it, you haven't brought before the court all the reasons why you say the status should be a different status to that which was given. So the other case that's been looked at as well is Saradar, and that's considered at paragraph 43 in Ulla. Again, in Saradar, it's if the Secretary of State wanted to take a decision of that character after a decision of a tribunal importing a right to ILR, his decision-making process would have to have a threshold. So you've established a right to something, the Secretary of State comes along and makes a decision, you haven't got that right. And what the court says, yes, you can do that, but you have to get over an evidential threshold first before you can embark on considering again there being a final judicial decision on whether or not you have a right to that thing. So those are very different circumstances in my submission to here, because none of those particular points of abuse arise. The only abuse that my learned friend has come up with is that, well, you ought to have appealed. It wasn't technically right to make a new decision, Secretary of State. But that is reverting back to what's impermissible. Because what is clear on all the authorities, and it's there in Ulla, if we actually look at it at paragraph 43, that there isn't that technical argument available. You can't say this decision is technically binding. It might be available if it were in the social security system. This goes back to what my learned friend said, and my lord put to him. can it really be right that you ignore the Secretary of State's decision and on appeal everybody then puts in their evidence and it's decided on appeal? And my learned friend tended to, or didn't pick up that point, to make clear that in the social security system, the appeal tribunal is built into the system. So the appeal tribunal will decide your entitlement to social security. So there's a Secretary of State decision, yes. If it's appealed, the actual decision in the appeal tribunal is you are entitled to universal credit. And so you could see in that circumstance, in order for the Secretary of State to then, I'm not sure there's even really room for the Secretary of State to decide entitlement, the Secretary of State might then look at for what period, you know, and do sort of, if there was any doubt about that. Normally there wouldn't be, because normally you would be, the date of claim was clear, and there's not normally any dispute about other components. But anyway, the Secretary of State wouldn't be able to decide again the question of entitlement to universal credit, because under the statutory appeal system there, that's just not open to the Secretary of State if the matter has been decided. That's not the case in the immigration system. In the immigration system, it is always the Secretary of State who decides the matter. It may be that there's no rational room to make a decision other than the decision of the tribunal, and that's what, in that sense, it's binding as a matter of public law. It just isn't scoped because everything's been considered by the tribunal, and therefore you are, particularly in asylum, implementing a tribunal decision. But the tribunal hasn't actually given you a right in a technical sense, but in every other, almost it's like a public law right, I think, or something that means that it is just effectively implemented. But that's not this situation. Here, there's been a decision on the application. That decision has been set aside, and the Secretary of State must make a fresh decision. No restriction on how that decision is made, and the Secretary of State being able to do it. So there is no abuse in the Secretary of State not appealing, because there's no limitation from the First Tier Tribunal decision that has to be removed.
And Mubu was a situation where, when it came to reconsider it, as you say, there was no room for reconsideration, and the original decision was arrived at on the second time.
My Lord, it was as you put to me before the short adjournment, that if what the Secretary of State had done is just say, I'm ignoring that First Tier Tribunal decision on exactly the same evidence, in exactly the same circumstances, had just taken a different decision, it wouldn't be an abuse in the sense of the Secretary of State was entitled to take a further decision, but it would be on deep sealing principles. It would be incumbent on the new tribunal simply to refer to the old tribunal and say...
Well, however you might frame it, it would be in the end public law irrational,
yes.
to simply ignore it and reach exactly the same decision on exactly the same material.
Yes, and the sort of re-litigation aspect, if that's the way of putting it, has been in the deep sealing guidance that you put there. It's not a binding threshold, so it's not a matter of binding, so it's not raised judicata, it's not all issue a stoppage, you cannot consider this. There's no support for any of that type of sheer face, rock face kind of thing.
So although you say conceptually it isn't different, you'd be inclined to accept, would you, that had there been absolutely no more information,
yes, then
the outcome might have been different when the matter went to the tribunal a second time?
Yes, where I differ, my absolute point of difference is it's not Ladder Marshall, it's Diva Sealand. And that may be, in some circumstances, a distinction without a difference. But I think that the reason it's important is because Ladder Marshall is associated normally with not being able to make a decision at all. And I think it's confusing to use cases where the abuse lies almost in making another decision without, and that's what my learned friend is arguing. Don't make another decision without removing the First Tier Tribunal decision, which you don't like or which you disagree with. And I think that is a conceptually different situation to you're considering the matter afresh rightly, as it were, and in that you've got to take account of, and the Secretary of State will accept that, you've got to take account of the judicial findings, as it were, that were made at that time on that evidence. And that is what Diva Sealand is really all about. That you put the judicial decision in its context, and you give weight to it in its context, but you don't create sort of binding procedural...
So I think I'm just noting that you don't push back against the proposition that the outcome might be different had there been no further information produced, and it had simply been the original information on which the Secretary of State had made the decision and which the Secretary of State had lost at the First Tier Tribunal. Then to do it all again raises immediate spectres of abuse.
Yes, I don't think I'd go quite as far as saying abuse. I think I'd say public law error.
Error,
Abuse
yes, I understand that.
Different connotation, I think. But,
and could I?
You're talking, sorry, about abuse of process there.
Yes.
In a sense, all public law errors are abuse of power.
Yes. I would say I can't help but the old days when there were procedural and substantive differences actually was quite helpful in some ways. So I think sweeping it all away and calling it all the same name, I'm not sure terribly greatly enhanced things. But I think anyway, it's certainly that is what would have been picked up by the judge, because this is really all about the second First Tier Tribunal making an error of law and approach. And if that had happened, what the second tribunal quite clearly would have done would have said, I'm not looking at that. He hasn't applied.
Right, so you say that Judge White was alive to that distinction.
Absolutely.
Could I just ask you about another matter before I? I'll just park that for a moment. I'll come back to you.
Yes. Would it help if I, my lord, if I just quickly picked up the other authorities and gave you sort of 2 lines on where I say, because it's not in what Fuller actually says is essentially if there's an established right to do something, before the Secretary of State looks at the question again, you have to have a threshold and you have to get over that, and the threshold happens to be ladder march.
The point that I wanted to ask you about is the distinction which you've been drawing a moment ago between cases where, as it were, the consequence of the earlier decision was that there was a right of ILR in some of the cases. And you distinguish that from the present case where it was no decision had been taken and it was sent back. Is that a conceptual difference in reality? It is. I mean, one might say, and I shrink to get into this area, and I know that my lords will prevent it from going too far. But one has cause of action estoppel, and one has issue estoppel. And one might very well say that if the consequence had been ILR, and that had been the end of the case, and all the Secretary of State was doing was restarting and trying to unsettle a settled grant of status, that was really an attack on the whole cause of action. Whereas here what is might be said to be engaged is an estoppel if it existed in this field in relation to an issue.
And to which, my lord, the simple answer is, even on my learned friends' authorities, it doesn't exist in this field. You don't do this thing of dividing up the question, are you entitled to leave to remain on your application, into these issues. And if we just picked up, maybe Abadiah is useful, page 125, paragraph 2 tells you what it's about, but at page 134, because just to remind you, Abadiah is the deportation case, where deportation decision was made. But if we picked it up at 134, at paragraph 44 and 45, these are the ones my learned friend took you to. When you read that, you might think this is directly against my learned friend, because if you look at what's actually said there, what's said is there is no rule of res judicata or issue estoppel, and it gives all the reasons, well, some of the reasons why that is. So, and one of those reasons is because it's always a decision-making process where you have to make a decision on the basis of the information available at the time of decision. That's the situation. So it really can't be seen in the sort of private law context, perhaps, of there's a dispute about a contract, the arguments are made, the dispute is resolved by the court, and you want to come back some years later and say, no, I want to argue about that contract again, or I want to argue about, because the court says no, you can't relitigate.
So you say it doesn't work by the identification of specific issues and then seeing whether there's estoppels and so forth. the authority is clearly against that. But you have, I think, accepted that there might be a case of which you say this is definitely not one, where a tribunal, when giving its decision, might make perfectly clear where it sees the situation in relation to a particular factual question, which might be said with such clarity that for the Secretary of State then to go back and seek to unpick that, other than by having appealed it, would place the Secretary of State in some difficulty.
Yes.
And so it isn't the operation of a specific evidential principle. It's the operation of the general public law duty as seen in this particular area.
And there is an element of respect for judicial decisions as well in there, as a sort of not very well formed principle of respect for judicial decisions. I think it's a combination of perhaps of these principles. But it's definitely not that you're according sort of binding force to the original decision. That can't work under the statute.
So it's the result, if it was ever to apply, it's the result of a general principle rather than a special principle.
Yes, I think that's right. I think that, it must be a general principle of administrative law that you accord appropriate respect to judicial decisions. And as I say, Refusal is really all about that. Refusal is really all about how do you place a previous judicial decision. When you know you've got to think of something again, you know you've got to revisit it. So there's no abuse in revisiting. How do you treat the previous judicial decision? And I would say it's as binding on the Secretary of State, the Refusal sort of approach of seeing that decision in its context.
Can I be sure I understand it? You accept that the Refusal guidelines should be applied as a matter of general administrative law by the Secretary of State in a case like the present, where the decision's been remitted to the Secretary of State to make the decision again. The Secretary of State should have regard to the Refusal guidelines.
No, I've misspoke. It's the principles that underlie the Refusal. Refusal is specifically about what does a tribunal do when asked to look at.
It's about a second tribunal looking at a first tribunal decision.
It's about that relationship.
I thought you had just said that the Secretary of State should do the same, apply the Refusal guidelines, but that's not what you're saying.
I didn't misspeak. Really what I'm saying is Refusal is a representation of approach as to how to consider a previous judicial decision. And it says, look at that decision in its context and respect it in its context, and only go back over the ground again if you've got some reason to do it. In the case we were just looking at, paragraph 45, my learned friend put emphasis on the word some legal justification, which is quite strange in a sense because Ladd and Marshall is really evidential. Ladd and Marshall's rules of evidence, so it all becomes a bit mixed up here. But in my submission, your legal justification is this has been remitted to me, and I must make a decision by law on this application. So that's the Secretary of State's entitled to look at it. And then the criticism is really of the First Tier Tribunal judge in this case, because it's not a judicial review, they can't really go back to the Secretary of State and say the Secretary of State erred in law, because that wasn't the appeal ground before the tribunal. So what's really being said is that the tribunal erred in law in not considering itself, in entertaining the question of whether or not there was fraud on those bank statements. And in my submission, there is no error of law in the First Tier Tribunal second judge's approach, because he very carefully looks at the matter. He's not blind to the fact there's a previous decision, and therefore there is some extra element that needs to be taken into account here, because there is a previous decision. And if we actually perhaps it's helpful to look at the other tribunal decision, which summarises this, or we can obviously go to the First Tier Tribunal decision. Hopefully the upper tribunal summarises it rather neatly, because in the upper tribunal, obviously the case that was put now before this court was put, whereas in front of the First Tier Tribunal, the judge was left to decide the matter without any restrictions being put on him. Yet still, even in that circumstance, when no one said you should look at it in this particular way or the other way, the judge doesn't just start again, you can see the judge does have that respect for the previous judicial decision and consider whether or not he should look at it again. So if we picked it up at paragraph 8 in the upper tribunal decision, you can see the appellant gave her evidence of the appeal for First Tier Tribunal Judge White and relied on 3 bundles. So the appellant is treating the matter as if it's all open for consideration again and putting in evidence on the matter. The matter which it's now said the judge wasn't entitled to look at. And then you can see the respondent also relied on 3 bundles of documents, including these document verification reports, further emails. And then the upper tribunal cites in full paragraph 8 of Judge White's decision at paragraph 9. I note that neither representative made submissions to me about the precise effect of Judge Randall's decision. Certainly it was not submitted that this was determinative of the question of whether false documents had been submitted with the application. And so that's why the judge then looks at the principles in due receiving, so he self-directs and says, I'm not just going to start again, which is what both parties appear to be saying was open in. I am going to look at due receiving and see whether this judicial decision should be treated in any particular way. He says yes, but he then looks at the circumstances of the case and says, no, I'm satisfied that there is good reason to look at this again, and he considers the evidence. Because there is new material. So if my learned friend was going to run an abuse case and say there was abuse here, it had to be run. It had to be an appeal, but the decision of the Secretary of State was not in accordance with law, and that there was that sort of knockout blow that the Secretary of State shouldn't have embarked on it. So in this court, and in the upper tribunal, there was a hurdle for the appellant to get over, which the appellant didn't address, let alone get over, and it's just said that while these are effectively binding decisions in order, and so it's really saying it's it's per curiam. But as we see, the has no binding principle in it that's relevant to this stuff. And there's nothing in any of the other authorities that really assist. And actually, my lords, you can see at paragraph 10, the tribunal looks at it carefully about how the judge analysed this, had new evidence from both sides, and he was satisfied that they were false. Because and also, as we picked up this morning, I won't go back over it, but Judge Randall very much made his decision on the basis of these November 2015 letters which had been put in, and the extent of his decision was clearly only that the Secretary of State hadn't met, in the decision before him, the standard of proof that was required. He didn't say it could never be met. He didn't say the Secretary of State should look at this. He didn't say anything of that nature. What the judge said was, I'm not satisfied. You haven't satisfied me on because of this new material. When we actually look at Judge White's decision, the greatest perspective from my submission is unimpeachable. It's completely fair. It looks at all the materials and he weighs it up and he hears all the arguments that are said in opposition, so paragraph 16. He looks at the arguments that have been run by the applicant in front of him. So they're not the arguments the Secretary of State shouldn't have looked at this. What the applicant's doing is engaging the Secretary of State's decision and the evidence and saying, because of this, when you consider the question of falsity, I should win. So when the judge looks at that, the judge takes that all into account, considers it very carefully. And paragraph 17, he summarises the position very clearly, because it really is a rather stark case in my submission. Because what's really being said well, there's no real explanation for the Secretary of State's evidence. And the judge says, really what must be being put forward is that the Secretary of State's manufactured those emails that say this is not from the bank, these documents don't emanate from the bank. Because the judge is satisfied that any sort of possibility of mistake or what have you has been ruled out, because the question has been asked 3 times and the answer has come back 3 times from different people. And so on the Secretary of State's side, he's not convinced that the evidence is forged or unreliable. And when he looks at the material that's relied on the applicant side, to some extent it's got worse. By putting in the further materials, it's called into question more and more what the position is. So in my submission, it's not challenged really on its merits anyway, this decision, but it is a decision that's bad. Because really the only decision that's challenged in this court, aspect of a decision that's challenged in this court, the First Tier Tribunal, is applying the wrong test to looking at it again. And then what's argued is, well, it's the Ladder-Marshall test, and the Ladder-Marshall test wasn't satisfied here, so the judge was wrong to sort of look at it. So they're all arguments about looking at the...
Yes, do you want to give us your submission on the position were we to conclude that it was a Ladder-Marshall test, and how that would apply to the circumstance in this case?
Yes, well, fortunately the upper tribunal does consider that. The tribunal does say, we don't consider it Ladder-Marshall, we consider it Stephen Sealand, but if it was Ladder-Marshall, it is satisfied here. And that, in all fairness, that really is also the position for the First Tier Tribunal, because in all fairness, it wasn't put to Judge White in Ladder-Marshall terms. So what you can't expect the judge to say is, I've applied Ladder-Marshall because I was told I had to.
Well, he sort of gave himself a Ladder-Marshall light direction on his own. But so, in a sense, you rely on the upper tribunal for the answer to Ladder-Marshall.
Yes. Right. But it's well-founded on what the judge below did, as it were. It's a substantive test. What they've done is they've stood back, looked at it in the round, and said, is there really... Because, as I've indicated, there may not be a lot of difference in certain circumstances between Diva Sealand and Ladder-Marshall, but my insistence on it being Diva Sealand is because that is the correct approach here, and I think it's confusing to start to use Ladder-Marshall.
But even under Diva Sealand, Mr. Malik showed us that one of the guidelines is if you're going to rely on new evidence, there has to be a very good reason, some very good reason why it wasn't adduced before.
Yes, I think one has to be really careful about this, right? Because Diva Sealand is not a statutory test, right?
No.
So if we elevate it to that, what Diva Sealand, they literally were guidelines in the case that was facing the position where you've got perfectly, no one's ever challenged the asylum decision, right? So the asylum judicial decision is sound, no one's ever challenged it. You're going to rehearse the whole thing again under a human rights decision. And so in that context, if you will then, when your human rights appeal comes along and you've been sitting on some evidence, and you say, right, my second vice chair, I'm going to sort of put this forward. That's what the tribunal was really looking at there. It wasn't saying, because of abuse of power by the Secretary of State, you know, we have to do this, or something of that nature. So when they're looking at the sort of very good reason, it's more of a turn of phrase than my... What they're saying is it justified to look at this again? That's what they're saying. If the evidence was there pre-existing, and it hasn't been put forward, you look at why that has happened. You don't say we won't consider it because it wasn't put forward. You look at why that has happened. And so applying that here, because there's no argument, if you're looking at Ladder-Marshall here, there's no argument that the material is apparently credible, and that the material could make a difference, the new material. So it's only that Ladder-Marshall principle about was it available previously. Now my learned friend says, well, yes it was, because we don't know when the Secretary of State would have been served with the bundle, when the Secretary of State would have got it in an appeal context. But my learned friend says that means it was available previously to the decision maker. I'd actually question that. It's certainly there at the hearing. That could be, but there is a difference between unless it's abusive for the Secretary of State not to adjourn, And unless the Secretary of State was bound to consider it within the context of that appeal, so the Secretary of State was bound to go back to the administrative side and to start to do the administrative decision making again, which seems quite different to the Secretary of State on an appeal arguing sort of legal submissions at a sort of an appeal stage. I think there is a difference there because we've established, I hope, that it wasn't necessary to remove the First Tier Tribunal decision. It's not that type of binding decision that means it has to be removed. So why then would the Secretary of State have to, what would actually have to happen was the Secretary of State would have to adjourn but to make a fresh decision. You can see what I mean? It's not as easy when you're appealing an administrative decision to say that the material has to be considered substantively. So I don't think the Secretary of State, by not adjourning the appeal and insisting on having document verification reports then, should be prevented from then, if the matter is remitted, considering it in the administrative decision-making stage and doing those processes then. There doesn't seem to be an abuse there, is the point I'm making. That these were different capacities in which then, so having it for a few days before an appeal, in my submission, is not the same as having had it all along and not considered it properly in your administrative decision, and then relying on it later when you had it at the administrative stage. So anyway, I think the short point, my lords, because we are in a slightly new territory there, but I think the short point is there isn't an abuse here. It was perfectly open to the Secretary of State to consider the material, and you have to set up the abuse by attributing something to Judge Randall's decision that inhibited the Secretary of State, and there isn't that there. It's definitely not an abusive process in my submission. So, and there is no abuse. It's not like the Secretary of State sat on her hands. What she's criticised for is not adjourning an appeal.
Do you dissent from the suggestion that the likelihood is that it was served 5 days or so before the hearing?
Yes, well, I've never seen anyone say that you could be sure in the this particular jurisdiction that somebody complied with the rules and served something on time, and infer that backwards from there not being a kerfuffle about it. I would say that there's a certain point at which the judges just get on with the job and sort of making comments about bundles and service of bundles and what have you. It's quite a pressured environment, and the judges tend to, you don't often hear them say, go back over the previous procedure and say, I noticed the bundles were late. Although it might be thought the other way around, that it's almost remarkable when everything is done at the time. So you might say, this has been a perfectly administered case.
Do we have any evidence as to when the Secretary of State first saw the 24th November 2015 letters?
It's never been put in issue, so we've never gathered evidence on it because it's never really been argued that you received this bundle on X date and therefore you had time to engage in document verification, or you didn't have time and you should have sought an adjournment in that.
Well, the most time the Secretary of State could have had was a fortnight, assuming that the letters were passed on by fingertip pass. They were received on the date that they were sent and that they were immediately passed on. And anything less than that is 14 days minus however long it took.
And obviously the verification has to involve others in a foreign state. So it's not necessarily a quicker process. It might turn out to be quick, but one can't assume that where others are involved. If it was just the Secretary of State performing a function, then you might be able to put a time frame on it. But if you're asking for people to respond,
well, it's not realistic to do it within that time scale.
No, it would have to have been an adjournment. The point that of criticism, if there's an abuse here or criticism here, it would have been, can only be the Secretary of State not adjourning, because it's not really practical to ask the Secretary of State.
Yes, because even if you'd managed to do it in 12 days, you'd then be presenting the applicant with something which she would want time to think about, and they would have to go off for that reason.
Yeah, and as I say, it's not as if the judge said something that was restrictive. The Judge Randall, it wasn't as if he gave a direction saying, you've had your chance, that's it, I've made a decision and I regard this as final, and there could have been a direction as to how the Secretary of State should proceed thereafter, but there wasn't. And So in my submission, there really just isn't any abuse here. It's not abusive. And that's what these principles really engage if they're not divasilen. And divasilen is, as I say, just a pragmatic approach to how you look at, absent these sort of ideas of res judicata and you can't do this. If you are looking at something again, this is how you treat it.
Remind me, is there some sort of general overriding objective principle in the tribunal's rules?
Procedural rules have a overriding objective at the beginning, and it is the fair and I think economic. I think there is that in there. It's two principles, and I think it's fair and economic. And then it does go on to rules 2 and rule 5 does go on to sort of split it down in more. But essentially, because the tribunal is a creature of statute, it has to make clear that it can do all these things like decide an appeal without people being present in certain circumstances, etc., etc. So you get. But it does have an overriding objective.
Is there a separate set of rules for each chamber of the First Tier Tribunal?
The upper tribunal certainly has common rules. I think what happens, you see, like in the upper tribunal rules, certainly there's a section for judicial review. There's a section for just asylum, immigration, and asylum appeals. And
but when you refer to rule 2 and rule 5, that's of the FTT procedure rules generally, is it?
Yeah, they're the upper.
Well, Rule 2 of the First Tier Tribunal rules is, not surprisingly, the overriding objective is to enable the tribunal to deal with cases fairly and justly, and then you have, of course, because we need it, what it means to decide cases fairly and justly in familiar terms. Dealing with them proportionately to their complexity, avoiding unnecessary formality and seeking flexibility in the proceedings, ensuring the parties can participate fully, using special expertise effectively, and avoiding delay when exercising rules or exercising powers or interpreting rules or practice directions.
Yes. So translating that across here, requiring the Secretary of State to appeal a First Tier Tribunal decision when the decision has to be remade anyway. The underlying application has to be reconsidered anyway. And my submission is the general thrust of those rules. If you've already set aside the original Secretary of State decision, so you know the Secretary of State, which had the potential problem with it in terms of meeting the standard to show fraud, it is a question of the Secretary of State kind of considering matters again, unless there's something that would restrict the Secretary of State in Judge Randall's decision, would restrict the Secretary of State. Other than just because there is a decision.
Can we just look at what Judge Randall actually says, which is at page 101 of the bundle?
Yes.
The notice of decision.
I can remember it, so don't.
So the respondent states in the refusal that the other elements of the rules have not been considered. The respondent in the refusal reserved the right to carry out the assessment of paragraph 245 DTH, but did not do so before me. Then there were no submissions on this, and no submissions on Article 8. And then paragraph 32 is the decision. In the circumstances, the appeal is allowed in respect of the general grounds, which is that it's deceitful. It's now for the respondent to decide on the substantive PBS application. Your submissions have all been premised on the basis the Secretary of State had to start again. I just wondered whether paragraph 32 is slightly more restrictive than that, and saying, well, we've dealt with the deceit question, now you have to deal with everything else.
The reason I read it that way is because of the way the preceding paragraphs were phrased in terms of, in this decision, the Secretary of State hasn't kind of met the test, as it were. If it had been more positive, if the judge had said, having heard evidence from this individual, and having looked at all the material, I find that there's no fraud here, then I would be more inclined to interpret the final part as that, shutting off, whether the judge can or not, but shutting off the general grounds of refusal in some way and saying, but it doesn't read like that when you read the previous. So ascribing that kind of intention to the judge, and as I say, it would be a fairly controversial intention. It seems unlikely. And in any event, as has been put to my learned friend this morning, it's actually really hard to compartmentalise because when you consider the substantive application, you do have to consider those materials because they're relied on for the substantive application. So you have to think, what do I do with these materials? And how do I consider them? And it would take something pretty strong, I think, not to consider them, given that you must make your decision on the circumstances at the time. And that's the sort of overriding principle of decision making. And so that's why I'm saying you have to kind of import something in to restrict. And just those lines from the judge there, without the sort of supporting abuse, if that's it, if it had all been aired and all been considered and it really was a done deal in front of Judge Randall, then you can see there might be the abuse in the Secretary of State when given evidence, but my submission is this isn't the ingredients there. The judge isn't purporting really to shut off considering anything relevant. And his decision is, on what I have before me. I have concerns, really. It wasn't actually even a positive decision. It was, you haven't made it out in your current decision.
Thank you.
But it does tie in with what my lord put to me earlier, which is if that was where it stopped, then there could be an abuse there, there could be a restriction there. So if that point was put and the Secretary of State really hadn't got anything further, then you could see that would be a much more powerful sort of point, because even if the First Tier Tribunal couldn't actually restrict consideration under the rules, as it were, there would be these principles that might say it's irrational public law, or however one wants to put it, to do that. And I've seen it many times. The judge might say, I actually had a case where it came round a second time for a judge, and his earlier, it had been a successful appeal, and the judge had really said, not now, that I'm not satisfied that there wouldn't be a risk of harm if someone was removed now, deported in that case now, because there are elections pending, etc., etc. So he allowed the appeal on human rights grounds as matters stood. And then, as it turned out, there wasn't so much election violence, it wasn't so bad, etc. And then later on, another deportation order was made, and there was a question of whether or not that previous decision was sort of binding, that this person wouldn't be safe. And again, these arguments about the quality of the judicial decision and whether that was and it actually, as it turned out, came up in front of the same upper tribunal judge. So the First Tier Tribunal had been persuaded that they couldn't consider again. And the same upper tribunal judge actually considered it the second time and said, no, that wasn't what I meant. Yes, I see, I might have phrased it in that particular way or what have you. But because everybody knows you have to make these decisions effectively, sort of on the up-to-date material, you can't sort of compartmentalise in that way and say that's, put a stake in the ground.
But that's slightly different, because there the issue is different. The issue is whether there is now a risk of harm, and just because there was a risk of harm 6 months ago doesn't mean there is now a risk of harm. In this case, the issue is exactly the same, which is, were the original bank documents false or not? It's just you have new and better evidence which casts more doubt on the veracity of the original document. So the issue is the same issue. The decision letter is based on the same falsity of the document.
I see that. I mean, actually, in that case, it was argued the First Tier Tribunal accepted it was the same issue and had been decided already, but that's accepted as error, what have you. So, in some ways, this is issue estoppel, isn't it?
Yes.
But is the issue? I think maybe it does come back to in cases of where you can show that the tribunal hasn't made a decision on the basis of the true facts. Maybe it is fraud that makes the difference. But I'm not sure. I think that in this jurisdiction, it's generally a pragmatic, sensible jurisdiction where you need pretty strong reasons on an evidential, procedural basis to make a decision that you know to exclude consideration of relevant material. And the court should be slow, in my submission, to construct legal principles that are meant to assist in decision making and make decision making stronger and more robust and more consistent. To allow those to be turned on their head, to really undermine decision making by preventing consideration of things that are relevant. Now, if there's abuse, that might be the justification for it. If there's abuse, it might be, well, you know, the public, as it were, just has to take the consequences of the wrong decision because this has been done in the wrong way, it's been abusive, it's been, you know, abused by a sexual state. But absent abuse, these principles, that's why I started really with, if the statute says you can do this, why can't you do this? Why should you do it in a way that's essentially suboptimal and gets you to the wrong answer? And we know it's the wrong answer, not just because the Secretary of State's reached the conclusion, but because it's been considered by 2 appeal tribunals on all the evidence. So it's not an administrative practice that's sending you the wrong way or something at the administrative level it's
I think we were told earlier that if the Secretary of State considers that a document is false, then there's a mandatory course that has to be taken, which is that the application fails on that ground alone. That's correct, is it?
It is, although here they did actually consider the substantive application.
Well, can we? This is what I wanted to just slightly unpick, because in relation to the underlying issue for the points-based system, the question, it concerns access to funds for entrepreneurship, does it not?
Yes.
And the documents are a means to an end by evidencing the underlying funds. But in the actual PBS decision, it is the existence or non-existence of the funds and the genuineness of their availability for a business. However, in both cases, the Secretary of State, as it were, thought it was appropriate to knock it out before getting to the decision. But you're going to tell us something about the second decision and how that was dealt with, are you?
Yes, well, the second decision was understood to be a substantive decision. So the Secretary of State couldn't say it hadn't been fully considered. It awarded 0 points for the funds bit, as it were, because what was relied on was that it wasn't as if anything other than the bank account was relied on as the source of funds. So the Secretary of State's rather tied into that. But if we look at all the
on page 88, are we? What page are we on?
Sorry, my lord. In my letter sent bundle, I think the about 103.
Sorry, are we in the second refusal decision?
That's what I'm just double checking. So,
It's 88.
Yeah.
102 is the first one.
Yes.
88 is the second.
That's why I was going up to see the
Yeah.
date of the decision before I said it to you. So it's already been raised earlier that the Secretary of State in the second one didn't say I haven't substantively considered funds. And in my submission, that is a material significant point, because in the first one, the Secretary of State stopped at general grounds of refusal, whereas in
Yes.
the
Well,
second,
if we look at the bottom of page 88, the application hasn't made it onto the second page. It's been refused at the bottom of the first page. So what were you wanting to tell us about the decision thereafter?
well, the difference between the decisions is that the
We got at the bottom of page 90.
yes. Well, if we look at page 90, you can see that some points were awarded for English language, as it were.
Yes. But
So
funds,
funds again.
no points. And the reason for the decision is linked, obviously, to the documents, as stated above.
But, my lord, that doesn't mean the whole application hasn't been considered, as it were. That's just the result of the fact that the way the funds are evidenced is through the bank documents. So,
At page 90, there's actually a statement involved that the Secretary of State refuses your application under paragraph 245DD as you do not meet the requirements.
yeah.
And I think that wasn't there in the first, or maybe it was there in the first one.
Well, my instructions are certainly the first time around, it wasn't considered substantively because the general grounds for refusal were considered to be, as they are, sufficient for refusal. But the second time around,
It did do it at the bottom of, sorry, page 104.
Yes.
Is that the same thing?
I mean, the first one did award points for English language and maintenance, but no points for access to funds, etc. And again, it says you don't satisfy the requirements.
In bold, just under the tables.
So I don't at the moment see what the difference between the two decisions is.
But I think it is that in the, make sure I got it right, on page 104, you have the reservation of right to carry out an assessment in the future, because that hasn't been considered. I just want to double check but that's absent. I understand it in the second.
Well, I think we established that it was absent in the second decision.
It is.
And what does it mean on page 104? We've not carried out an assessment as detailed in paragraph 245 double D little h.
It means that they haven't considered they've found fraud and rejected the application, and so they haven't decided on any other basis of the requirements to be an entrepreneur. So say you have to satisfy points 1 to 5 in order for the application to succeed, and normally they would actually consider 1 to 5, even if you failed on one, they would go on to consider the other points. But in the case of fraud, they just said you found the general grounds for refusal, that sort of point 0, I suppose. You don't get off the ground because you failed on the general grounds for refusal. So we haven't gone on to consider 1 to 5, and we reserve the right to consider 1 to 5.
I wonder if that's right, because if that had been right, why does page 103 set out that you need 75 points and then say you haven't got any points under this head and you have got points under that head, and then the bit in bold on 104 gives 2 reasons for refusal. One is paragraph 3221A, which, as I understand it, is a deceptive documents mandatory ground, but it's also refused under 245DD, which, as I read it, is because you haven't got 75 points. And the reason you haven't got 75 points is you've been given 0 points for the funds and so on. But it does look just like the second decision, as if both grounds have been considered and put forward as reasons for refusal.
I think there is a difference. Whether it makes any difference overall to the appeal, I'm not sure. But the first time around, the decision would be in that form because that's because as a result of your documents being rejected, you don't meet the funds requirement. So it's right, even if you're just refusing on the basis of documents alone without doing anything else, you'd get a decision in that form because you don't meet the rules, because your evidence that you rely on to meet the rules is defective, and so we're not going to give you any points on the basis of it because we just don't accept it. So you would expect on a general refusal, general grounds of, if the refusal was you're a criminal, say, or something like that. So the general grounds of refusal weren't the fraud grounds, but there was some, there isn't actually general ground of refusal that you're a criminal, but say it was that, something that doesn't mean the documents are necessarily wrong, that you rely on. So you might have a perfectly fine application that's refused because of some other criteria that the general rules make you have to satisfy. So the application's fine, but you've been locked on that. But here, the requirement actually is in the application itself, because it says you have to give us evidence of funds, and the evidence you put forward of funds isn't good enough, and also because you decided it's fraudulent, then you get the general grounds for refusal coming in. So you'd expect that in the first refusal without a substantive consideration. My understanding is the difference is that, and you can see the Secretary of State's reserving the right to look at the rest of the application if it turns out that bit's wrong, as it were. So don't take this decision as meaning we've checked out whether you're an entrepreneur on points 1 to 5 and are satisfied, because we haven't gone that far. And that's what that first letter makes clear. The second letter is still to be expected because the documents have been found to be fraudulent, that you don't meet the requirements. But the Secretary of State hasn't, so it's in a sense a sort of a point where the Secretary of State is saying we've considered everything. So there you might be able to rely on the absence of any challenge to any of the other points. So if you understand, so that if this goes back to the Secretary of State and the Secretary of State says, we didn't consider, because we refused on general grounds of refusal, we didn't consider the other points, as it were. Then you might, my friend might on the second letter be able to say, well, too late, because you didn't reserve the right to look at those other points. You gave the impression that you had considered everything.
There is there is a difference which I've just spotted, which is that in the first letter, when no points are awarded on page 103 for access to funds, the reasons given is the general grounds for refusal, in other words, for deception. Whereas on the second letter, the reasons given is different, page 89. The reason is because the documents are false, and they've been verified as false. Now, I mean, the consequence is exactly the same, but your explanation is that's a different process because you've actually considered. And on the first one, you haven't considered it at all. You've just said this has been rejected under the general grounds, and so you get no points. But under the second one, you do actually look at it and say, well, the documents are false, so they don't prove what you need to prove.
Yeah. I mean, I don't know how much it matters, apart from...
No, it may not matter at all.
In the scheme of things. I think it only matters if there's any question of whether it's a binding... if my own friend has established registry or even perhaps something that restricts the Secretary of State from considering...
If the appeal is allowed, you accept it, it has to go back to the Secretary of State to decide again. The question might then arise, what's open on
yeah,
that?
what's open at the decision. And I think that's the only context, but because res judicata hasn't been established in my submission, my learned friend relies on Ladd and Walsh or something of that nature. So there's not you can't condition what's open on the second decision-making process by any principle of law that excludes things. The best my learned friend can do is put in a Ladd and Marshall threshold. But if he chooses to put it in at the appeal stage against the adjudicator, as it were. So I think it would matter if there were those sort of legal principles that condition it in that way. You know, what's the scope of the decision-making process? Then it would matter. But I don't think it does. So.
Very sorry. It may, as you say, it may not matter.
Yeah,
My law says it may not matter. Page 104, the in bold is it decided to refuse your application. And at the end, as you do not satisfy the requirement of paragraph 245 double D little a, which is general grounds for refusal. So that's how it's put there. Page 90, refusal, you do not meet the requirement of paragraph 245 double D little b, which is the requirement to have a minimum of 75 points. So the reason for reaching the second conclusion, as my lord has pointed out, would appear to be the fraudulent bank documents, but it is a different decision.
Yes, it's a different route in that sense. It's that having assessed your application, because in my submission it is material that in the first decision there is this reservation of right.
Yes.
Whether you can actually do that is another question entirely, of course, but the language is trying to convey, we haven't looked at it substantively, overall, all the aspects of the rules, under the rule that's mentioned there, we haven't examined it under that rule.
Could you let us have copies of paragraphs 3221A and 245BD as they stood at the relevant times?
Yes. I'm not even sure. Certainly 322 hasn't changed. Whether the unfortunately named and numbered rules on this, because I know the entrepreneur route's been the subject of much use and so it's been changed, but whether it's the same. So we will try to sure Mr. Lamb and I together try to find the right slot.
Yes, well, I've just been looking at what's currently available, so maybe it wasn't the same in 2000.
Yeah, well, it's almost certainly not the same if it's the entrepreneurial route, but whether the material difference is
Yeah.
question.
I mean, it would be surprising if little a and little b were different.
Yes, I mean, one would hope that the basic requirements haven't changed, even if this is the same amount about bank statements. What happens if your bank statements are out of date, etc. But anyway, we can get to the bottom of that. As I say, I think in some respects, I think my sort of overriding submission is it probably won't make much difference to the principles that are here, because the justification for ladder marshal is to really guard against abuse, and there isn't an abuse here.
Yeah. So I'm just looking at 245DD on the assumption that it's pretty much the same as it was then. So the way it seems to work is that there are 20 requirements, of which we've been considering but 2. If you meet those requirements, then you're entitled to leave.
Yes.
But many of the requirements are judgment calls on a balance of probabilities for the Secretary of State about the genuineness of the business and the business plan and so forth. And obviously not cases about that sort of question. So basically there's a long list, but if you manage to get through all of that, then you get leave.
Yes, I think that might explain the language of reserving the right, actually, because the general, as you're probably aware, the sort of general thrust of the PPS is the idea that if you meet the criteria, you're entitled to leave.
Yes.
Rather than sort of a general exercise of discretion where the individual decision maker has quite a sway. So here, the individual decision maker has a sway, but only restricted within those requirements, quite a very narrow. It can't be a complete discretion in the sense of other systems. The system is aimed at giving a sort of sometimes it's a tick box, isn't it? But as my lord indicates, it's not really tick box in the sense that's commonly understood. There are still some evaluations in there, but not a broad discretion. So I think that would account for the language why the Secretary of State is making it clear they haven't evaluated the sort of 19 points. They just said on 20 or whichever one it is, the funds. On the first time round, it's fraud, so we're refusing it without considering 1 to 20. On the second time round, we consider 1 to 20, and the reason you don't meet the fund requirement is because your documents can't be reliable to prove that you've got the funds.
Yes.
So, I mean, the documents probably could have been not accepted without fraud, as it were, because underneath it all, the obligation is on the applicant to provide sort of evidence. But in this case, I think I would accept that because it is fraud that's relying on it, there's an issue in some respects. But you have my submissions. There's no legal restriction. So it has to be read in by principles, and none of the principles that my learned friend relies on as such that would make this first tier tribunal judge second time around err in law, materially err in law. And that's just the only other point would be that the upper tribunal considered carefully whether, even if there was this distinction, even if it was ladder marshal, even if it would make any difference, and they found that essentially a materiality point here, which must still apply also in this court, in that if an error of law must be a material error of law. So even if the judge applies a test that's not phrased in terms of ladder marshal, but is phrased in terms of deep sealing, and this court found that didn't really, in this circumstance, sort of cooperate, say that there is something different there. Is it enough to make the difference to mean that this decision overall can't stand? Because it is accepted by my learned friend that we're not in the res judicata realm where you can't look at it at all. We're in the threshold realm where my learned friend says there's a threshold. So if it's been found that, well, the tribunal doesn't accept there's a threshold, but if there is one, it's been met, then in my submission, in this court's discretion. If this court found the decision was otherwise sound, having, as I say, had a first tier tribunal look at all the evidence and consider the matter carefully, and then the appellate tribunal will also consider it. It's my submission that this court isn't compelled to allow the appeal, and if it did go back, it would be a rather odd situation, because unless there is a rule that says you cannot look at this,
well, we'd have to do that work ourselves.
I didn't understand my learned friend to ask you actually to decide the appeal.
Well, I don't suppose we're going to.
As if you were the first.
We're going to, if we allow the appeal, do so with anything other than clarity about what the consequences
Yes.
might be thought to be. So it would be pointless, would it not, for us to allow the appeal, but to sit on our hands about what the tribunal was then to go ahead and.
My lord, sir, at cross purposes, I thought you were going to sort of rehear the.
No, not at all. But I'm just saying. I'm just saying that if the upper tribunal got it wrong,
yes.
And that the appeal should be allowed, well, then it would seem to fall to us to say what we meant in allowing the appeal, and
Yes.
what was and what was not covered.
So, my lord, you would stand in the upper tribunal's shoes, which would be: does this need to be remitted? Should it be reheard at the upper tribunal level? Because where there's a successful appeal against a first tier tribunal decision in a statutory appeal context, then the upper tribunal can decide whether or not there's findings of fact that need to be done, then it will remit it down. Generally, it will probably hold it, so it would be the same sort of consideration, because you'll be exercising the same powers as the upper tribunal.
What are you inviting us to do if the appeal succeeds? Obviously, if the appeal is dismissed, the question doesn't arise. But if the appeal succeeds, what order are you inviting us to make?
Well,
Because I understood Mr. Malik to say the consequence of a successful appeal would that it would be to go back to the Secretary of State to reconsider the decision, but in circumstances where she could not reopen the question whether the bank statements were fraudulent, because that had been decided by the first FTT and it was wrong of the second FTT to go behind that. So I think we do need clarity from you as to what you say we should do if the appeal were allowed.
Well, my learned friend must accept that you can only put that bar in place if you had decided as a court that the Ladin-Marshall test couldn't be surpassed. Because it's not an absolute bar.
Yes,
You cannot
I think when now moving to the point
Yes.
where Mr. Malik had succeeded,
Yes.
we just want to know what order we would then have to make in your submission.
Yes. Well, I think in the scenario that Mr. Malik had succeeded, it would have to be that the Ladin-Marshall test applied and the Ladin-Marshall test was satisfied of the evidence. Wasn't satisfied.
satisfied.
So then it would have to be there is no justification for revisiting this, and so I suppose then that would be the Secretary of State would be bound to consider the appeal, the application, assuming that disregarding the subsequent evidence and assuming that because the Secretary of State shouldn't have had regard to the later evidence. That would have to be so. It would be just looking at the evidence that was before the First Tier Tribunal with Judge Randall and following the approach of the First Tier Tribunal. My learned friend can't get more than Judge Randall gave, as it were, because that's where all this comes from. It comes from Judge Randall's.
So it would go back to the Secretary of State for a third decision on the basis that the Secretary of State was not entitled to challenge the material that was before Judge Randall for its genuineness.
Yes, because of Judge Randall's decision. Yes, the Secretary of State had to give effect to Judge Randall's decision.
Right. So the Secretary of State would then have to consider access to funds on that basis.
Yes. It would give effect to Judge Randall's decision, so it would have to be and disregard the subsequent evidence. So I think that must be that. I mean,
That sounds as if you're agreed with Mr. Malik.
I'm trying to work through because there's the problem we've had is that the fraud is a component of the rules, and it's working through that, isn't it? That
Yes.
you've still got to consider the rules. You can't stop the Secretary of State from considering the rules. So so your issue is stop, as it were, it's how wide your issue is framed, isn't it? And my learned friend's framing the issue on that the bank statements are genuine, I suppose. So
Well, that's what Mr. Malik very clearly said to us. The Secretary of State would have to reconsider on the basis that the bank statements were genuine, and the Secretary of State could no longer dispute that.
So on that narrow basis then, so if there was material that went to other things, even to funds, whether the funds were available, so the bank statements say they're there and they're there. If there was evidence that meant, yes, they were there at that time of the bank statements, but we now have evidence that they were siphoned off, straight away, or something else, that meant that the statements are genuine for what they speak to, which is the funds were there at that point in time, but that those funds weren't available to the individual because of, there was someone else's funds or something of that nature.
Well, how does this work? I mean, it might be thought to be pretty unlikely that funds that were said to be there in 2018 have simply sat there in the same sums in 2022 by the time we get round to this.
I did wonder that myself, my lord, whether...
But I mean, the Secretary of State, presumably, if considering the matter for the third time, has to consider it at the time of the third decision. And so it would be unreal, wouldn't it, for the Secretary of State to be fixed, whatever the legal principle is, nothing to do with that, but to be fixed with bank statements that were 3 years out of date as a basis for carrying out the rules.
But what I think my learned friend gains from the appeal, because one might say, well, why is that the general grounds for refusal say if you've committed fraud, then they have wider implications,
yes,
as it were.
On subsequent applications.
So it's removing that decision there has been fraud here in the past, I think is the main purpose of it, rather than sort of say you can't consider the funds. This is why I was trying to be careful, because...
Does it come to this, that if the appeal is allowed, the Secretary of State, if we accept Mr. Malik's argument, is bound to accept that the bank statements were not fraudulent when they were produced, but the question of whether all the other requirements in paragraph 245DD are now satisfied remains entirely open. So that, as you say, Mr. Malik gets rid of the finding of fraud with the consequences for future applications, but it doesn't lead to any particular consequence for the decision as to whether the requirements can now be met.
Yes. The only other nuance I'd place on that is that the bank statements are true for what they say, that there are funds in the account.
Were funds in the account on that date?
On that date, because that's what the dispute
That doesn't
is
mean
about.
there are funds in the account today.
The point I'm getting to, my lord, is not actually the dates point. This is a further point, which is that are those funds available to that individual?
Yes, just because there are funds in someone else's name in a bank account does not mean you've satisfied the requirement.
What the Secretary of State can't do is say, because you were a fraudster about the funds because they weren't really there in that account, we don't believe you, or the Secretary of State doesn't believe you about the other aspects of it. But if there was evidence that went to the other aspects of it, like should have never met these people, or there was some other material that came to light that it's Bangladesh, so these were professional organised crime providers of funding for the purpose of immigration applications, and therefore those weren't individuals named personally or something, it was all part of the scheme. Then I think the Secretary of State could look at that and so, although the point is going to the funds that are in the bank account, it's not the same point of the funds aren't in the bank account of that person. So I think it must just be for what the statements speak to, which is that those funds were there in that name.
Right, so that's been very helpful, at least to me. So it doesn't, you say, much hamper the Secretary of State in starting again for a third time, but it removes the badge of shame from the applicant.
Finding of fraud, which has been upheld by so all the judicial decisions couldn't be relied on either, because they would all be set aside. Presumably, if the appeal is allowed, it would set aside the First Tier Tribunal and the automation. That's a detail of the order when it comes, but it would be setting aside all those judicial decisions as well. Unless I can assist further.
I did have one question, which is that your submissions did not really rely on the fact that the 24th November 2015 letters were themselves fraud. You haven't put it on the basis of this is a fraud on the First Tier Tribunal, and that's a reason why we can look at it again. You put it on a much broader basis, that is, it's remitted, so we have to look at it again. Is it a significant part of your case that the First Tier Tribunal, first time round, was deceived into accepting the November 2015 letters?
Mine's a defensive case, as it were, so
Yes.
I've responded to what's been put there. I haven't actually put a causative case of, and here are other reasons why. Perhaps it would be in... but certainly what my learned friend is really relying on are equitable principles. He has to construct a principle that says it's unfair. You know, I've gained something by this First Tier Tribunal decision. This is the root of everything, Judge Randall's decision.
Yes.
I've gained something by it, and therefore that must stick. And it gives me these rights, apparently, you know, not rights in the broader sense, you know, that I've achieved something here and I'm allowed to hang on to that, and no one can do anything about it because they haven't followed the appeal structure or haven't, you know. And that's the heart of it. And so if you were never really, they're equitable principles, if you were never really entitled to that win, and you got that win by relying, you know, practicing a fraud on the tribunal, then it must be right that the court would have in its discretion, you know, the right to say we don't allow someone to profit from fraud. So it's not necessary for my case, as it were, but it is something that my learned friend has to reassure you that these equitable principles, these general principles, can apply here to assist, because there's an unfairness here. There's no unfairness. There's absolutely no reason to be doing it. As I say, if it was the case that there was a sort of... sometimes a judicial decision is binding until it's set aside, whatever the merits of that decision. And so you have to set it aside because it's that type of structure. But that's not this structure here, is really what it comes down to. So my learned friend has to rely on equitable principles. Some judge-made approach that says there's an unfairness here or an abuse here or principle. They're not all negative principles. It could be, I say, how to deal with this problem of you've got two judicial decisions covering the same territory.
Thank you.
But it must be right. The court isn't bound because there's not something saying it has to apply a decision because it's not been set aside. So we're not in that realm.
Right.
Unless I can assist by other ways.
No, thank you very much indeed, Ms. Allison. Yes, Mr. Malik.
My lords will recall that my learned friend on the issue of test submitted that in this case, Judge Randall had given no direction to the Secretary of State to act in a particular manner. And my learned friend says that that is significant. My learned friend also says that it was merely a remittal in the same context, and in answer to a question by my lord has also placed reliance on the fact that this is a case where the allegation is that the fraudulent documents were provided at the appeal stage. Now, these submissions with respect are entirely inconsistent with the authority. Just to deal with the directions point first, tab 5 of the authorities bundle, the case of Ullah again. May I take my lords to paragraph 23 of that judgment. So this is where Lord Justice McComb refers to the judgment of this court in the case of Balfour. The directions point was made in that case and was rejected. Now, if you look at the quotation, which is at paragraph 23 at page 116, you will see that there's reference to Yusuf about the executive making use of available machinery of appeal. And you'll see the point that is made. And then the directions point is made in the next paragraph, which is paragraph 26. the Secretary of State argued that, well, the adjudicator in that case had not given any directions. But the court said that that is irrelevant, and this court disagreed with the judge that the adjudicator's decision without direction is, by reason of their absence, not binding on the Secretary of State. So that is the answer to the directions point. And if you then look at the last paragraph, is paragraph 28, and see the last sentence, again, the directions point is made and is rejected.
So the directions point here seems to refer back to paragraph 22, does it? Directions as to the implementation of the appeal decision as required by section 19.3. Those are the directions that were available but were lacking. This is, I understand you're trying to meld that with, as it were, a steer.
Yes.
But this appears to be a particular statutory implementation provision, which was missing. Well, is that what we're concerned with at all here?
Well, I mean, of course, that was a case decided in 2002. In this case, but what was section 19.3 of the 1971 Act, the equivalent to that is section 87 of the 2002 Act, which was again abolished by the Immigration Act 2014, but applies to this case. That empowers the tribunal to give directions for the implementation of its decision as to how that decision should be implemented, whether the Secretary of State should grant leave to remain to an applicant, whether the Secretary of State should reconsider in a particular manner. But the fact that there were...
But in this case, there was a direction, which was to remit. So how do we come into a question of whether or not directions were given, when directions were given, but they were not specific to the point?
So the submission is that the fact that the judge did not give a direction at the end of the decision saying that, well, the Secretary of State should not revisit Rule 322 decision does not assist. And I do also submit that this isn't a case of a conventional remittal in the sense that a person applies for judicial review, the judicial review court is not a fact-finding court, it quashes the decision, sends the matter back to the Secretary of State, remake the decision. That is a remittal in a conventional sense. In this case, there was no remittal of the decision under Rule 3221A of the immigration rules. That issue was decided, that issue was not remitted to the Secretary of State. And one simply has to look at the notice of Judge Randall's decision to see what was decided. Judge Randall decided the issue as a matter of fact and then remitted the matter to the Secretary of State for consideration of other issues.
But how do you deal, for example, it was going to take a certain length of time for the reconsideration to take place. I mean, whether it be weeks or months or longer for that to be done. I mean, what's the reality? Months?
Months, yes, of course, yes. Yes.
And at that point, the Secretary of State is, one would suppose, entitled to say, well, let's see your source of funds. Is she not?
Yes.
So where does it get you?
Well, the Secretary of State cannot say, I mean, this application, of course, was made in 2012, and it's unrealistic to expect.
I understand the Secretary of State can't say, we're going to turn you down because back in November you produced forged documents.
Yes, but she will say that, well, where is the access to funds?
Yes. And
the appellant would say that, well, here you go. This is another bank statement that I put forward, or my money is now elsewhere.
Has the Secretary of State got to accept that at face value?
No, the Secretary of State will if the appellant provides that evidence, the Secretary of State will consider it and will make a decision about it as to whether or not the appellant has access to it. But
your point is a very narrow one, which is that what Judge Randall decided was whether the original bank statements were deceptive. And that's the decision you say the Secretary of State could not go behind, because that's not remitted, that's decided. That's your point.
That is the only point that I make in this appeal. I mean, if of course I'm right about this point, the Secretary of State can obviously revisit whether the appellant is entitled to points and ask the appellant to provide updated evidence as to where the funds are, and the appellant may or may not provide evidence of those funds, and the Secretary of State would make a decision. I mean, things have obviously changed in the last 10 years. There are other provisions of the rules under which the appellant may qualify for leave to remain. So the sole objective of this appeal is to get rid of as my learned friend pointed out, to get rid of the
finding of deception
in relation to those bank statements.
And it does have consequences in terms of our other applications.
Absolutely.
So there's a practical consequence, even if you accept that if the Secretary of State has to start again, we'll be looking afresh at all the evidence that's now available on what's now the position.
Absolutely. Yes.
Well, I think I understand.
Yes.
Can I ask you something else while we're looking at this passage?
Yes.
On 116. Just under halfway down, there's a citation from paragraph 28 of Lord Justice All's decision in Bav.
Yes.
I can't pronounce it. Bavfo.
Yes.
And he says, there may be circumstances in which the executive may reopen a decision without appeal. For example, because there is fresh evidence, say, of deception.
Yes.
And I think that's picked up in this judgment later on at paragraph 42. The
Absolutely.
Entitlement to reopen decision in the case of deception was acknowledged in Bavfo. Why is that not the case here?
Yes. So the answer to that question, my lord, is that if you look at paragraph 24, so that was, yes, paragraph 24, the second paragraph in the quotation, page 117. So that was a case where there was an appeal, and the Secretary of State took the view that the favorable appeal decision was obtained by fraud.
Yeah.
Something very similar that has happened here. There was an asylum appeal, the appeal was allowed, the Secretary of State took the view that there was fraud, and the Secretary of State relied on evidence that came to her attention after the tribunal hearing. So that is the fraud at the tribunal.
Yes.
But then see paragraph 25. The court says that in that case where there is fraud, even in that case, the Secretary of State is not entitled to disregard the tribunal's decision unless the Secretary of State follows the appropriate procedure. And then the court explains that the Secretary of State can only go beyond the adjudicator's decision if Ladd-Marshall test is met. Even in a case where, just like this case, the allegation is that there was fraud with the tribunal.
Yes, I see. Thank you.
So in my respectful submission, it's just impossible to distinguish that case from the present case. Now, my Lord referred to the judgment of the Supreme Court in Dhaka earlier this morning. There is actually a decision by the upper tribunal's president on the implications of Dhaka in this jurisdiction. It does not conclusively resolve the point that the president essentially said that it is doubtful whether Ladd-Marshall applies to an application to set aside a decision that is obtained by fraud. And the president then said that, well, if Ladd-Marshall does not apply and it's simply a matter of discretion, then as held in Dhaka, then what would be relevant to the exercise of that discretion is the ability or inability to identify fraud during the course of the original trial. I mean, I can give my lords the reference to the authority. I can provide it. Yes. If my lord is interested.
What is it?
The case is Abbasi, Abbasi, and the neutral citation is 2020 UK UT 27, and the relevant paragraphs are paragraphs 44 and 45. That was a case where the upper tribunal allowed an appeal, and on the basis of a letter submitted by an accountant. The decision was then published online, and the accountant concerned wrote a letter to the tribunal saying that, well, there's my name in the decision, I know nothing about this, I never wrote the letter. And then in those circumstances, the president decided to reopen the appeal and then substituted a new decision dismissing the appeal. Ironically, both the parties in that case argued that the tribunal had no power to reopen the proceedings, but the president took the view, applying Tucker and Gladden Marshall, that it was opened up. But that is that. And then Miller and Friend on this point submitted repeatedly that, well, the Secretary of State would give respect to the judicial decisions. But this, in my respectful submission, is again inconsistent with the authority. It's not merely a matter of giving respect to judicial decisions. Access to tribunal is akin to access to court, and the Secretary of State is obliged to comply with the judicial decisions, not simply to respect those judicial decisions. Now, you'll recall that Miller and Friend submitted that it's not Gladden Marshall, which I say is inconsistent with the authority, and she submitted that it's Devasaline. And when she made that submission, my lord asked a question that, well, even if one looks at Devasaline, there is a reference to there being very good reason for not adducing evidence. And then Miller and Friend seemed to have changed the position and said that, well, Devasaline itself is quite flexible, and the ultimate test is whether departure from the earlier decision is justified. Now, I have proposed a test, namely Gladden Marshall, that is principled, that is consistent with the authority, and that is workable in practice. I do ask my lords to consider as to how the test that Miller and Friend puts forward, namely whether departure from the earlier decision is justified, is workable in practice. What does that mean? And on that test, this merry-go-round will never stop. But even if my lords take the view that Gladden Marshall has nothing to do with this case and it's Devasaline, then Mubu is the authority where the tribunal applied Devasaline principles and read those principles so to mean that if the Secretary of State fails to adduce evidence that she could have adduced with reasonable diligence, then she cannot subsequently complain or seek to reopen the decision. So even on that principle, in my submission, the appellant succeeds. But even if Devasaline does not apply and it's simply a matter for a judge's discretion, and it's simply, the question is simply whether it's justified, and there's broad discretion. In exercising that discretion, a judge must have regard to the principle of finality in litigation and the one-stop appeal framework. So even if there is discretion, it has certain limitations, and the judge below simply failed to take account of these principles. And for these reasons, in my submission, the decisions made below cannot stand. Now, the second major point that Miller and Friend made was that, well, the appellant did not argue before the tribunal that there was an abuse of process by the Secretary of State. There was a res judicata applies, no point as to estoppel was made, and there was no unfairness. I do not make any of those points. I do not say that this is a case of abuse of process or res judicata or estoppel or unfairness. I mean, I've considered that categorically in my replacement skeleton. But I do not need, I do not need to make an abuse of process or res judicata or unfairness point to win on the argument that I have made. True it is that the relevant authorities were not brought to the judge's attention. I've made a submission that this is a specialist tribunal, ought to have been aware of the law. If I'm right about my primary point that the judge got the law wrong, then it's no defense that the authority was not brought to the judge's attention. One can obviously criticize those who were representing the parties at that time, but that does not save the decision. And as part of this argument, at one stage, Miller and Friend also suggested that the appellant should have applied for judicial review of the second decision. Judicial review wasn't available to the appellant because there was a right of appeal. if the appellant had applied for judicial review, that judicial review would have been knocked out on the basis of the alternative remedy. Now, thirdly, Miller and Friend made submissions about the merits of the decision taken by Judge White, and she says that Judge White considered everything, came up with a fair decision. There's no appeal against the merits of that decision. I mean, the complaint is about Judge White's entitlement to embark on the fact-finding exercise as opposed to how that exercise was conducted. And then Milords will recall that Milords asked a question to Miller and Friend that if Ladd and Marshall test applies, why Miller and Friend says that that test is met. And Milords will recall that Miller and Friend stated that she relies on the upper tribunal's reasoning. But she has not answered any of the submissions that I made about the upper tribunal reasons. The upper tribunal, as I pointed out in my opening submissions, held at paragraph 26 that the two letters were put before Judge Randall had not been put before the respondent, and the respondent had no opportunity to verify those letters. This is paragraph 26. That conclusion cannot be justified. Miller and Friend does not defend it. If Miller and Friend does not defend this conclusion, it's very difficult to see how she can then submit that Ladd and Marshall test is met.
Are you sure? I mean, what she's saying is the very earliest that these letters were shown to the Secretary of State was the 24th of November, assuming that their date bore any resemblance to real life. So at the most 14 days, you tell us that the bundle would have had to have gone in 5 days before. Why is a judge of the upper tribunal not to inclined to say, well, entitled to say in those circumstances, in real terms, the respondent had no opportunity to verify?
Lord, with respect, this is not the judge, what the judge says, and I do invite my Lord to consider the way in which the judge has expressed herself, that these letters were put before Judge Randall, which had not been put before the respondent.
They hadn't been.
Well, not with the application, sure.
No, but they hadn't been put before the respondent. They'd been put in a bundle and given to the court. That's not putting them before the respondent.
Of course, that bundle, then in the that bundle, of course, was served on the Secretary.
Well, one might suppose it was, but I mean, you know, if we're getting technical about this, it doesn't seem to be a very persuasive point. That it wasn't that you went to the Secretary of State and said, you know, hold on, this wasn't it. Here is a letter. Could we please consider this so that I don't have to pursue my appeal? You put it in a bundle and put it before the court, and the Secretary of State then got wind of it because the Secretary of State's a party.
Yes.
I mean, so, you know, if we're splitting hairs, that might be a hair-splitting way of putting it.
Yeah, I leave the point.
Well, Mr. Marriott, before you leave the point,
yes,
I'm concerned that we don't actually know at all when the Secretary of State or her representatives first saw the 24th of November letters.
Yes.
It could have been on the 24th of November. It could have been 5 days before the hearing. It could, for all we know, have been on the morning of the hearing. But the truth is, we have no real evidence. Now, how can we start deciding whether the Secretary of State had an opportunity, a proper opportunity, to obtain evidence answering the 24th of November letters when we don't have the facts which will enable us to make any judgment on that at all?
Absolutely. So if a party seeks to rely on new evidence, then that party has to demonstrate that the evidence could not have been obtained with reasonable diligence.
So you say the onus is on the Secretary of State to establish that.
Absolutely. So
but
yes,
the Secretary of State did establish that to the satisfaction of the upper tribunal. We don't know what happened, or on what basis the upper tribunal judge came to that conclusion. You're inviting us to reject paragraph 26 of the upper tribunal's decision on the basis that it cannot be right. But I feel, speaking for myself, great difficulty in deciding whether paragraph 26 is right or not, because I don't think I have the material to do it, and it's your appeal to us to say paragraph 26 can't stand. But how can we decide that? I understand the point that
Yes.
if you're going to say Ladder Marshall is satisfied, it's for you to say it. But the Secretary of State did say that before the upper tribunal and succeeded in persuading the upper tribunal. And it's you who are saying to us the upper tribunal made a decision that really wasn't open to them.
It's my fault, I'm sure. I read paragraph 26 so to mean that the judge was saying that these letters were not provided to the Secretary of State at all, as opposed to they were not provided to the Secretary of State with the application.
No, it's tolerably apparent that the judge is saying that the letters got there too late for the Secretary of State to verify them within the timetable that had by then been set. Now, there are obviously various possibilities that could have happened. The Secretary of State could have tried to pull out and say, I need time to deal with this. The Secretary of State could have tried to forge ahead, as she did. Or the tribunal could itself have said, well, this is all very unsatisfactory. Instead of my trying to make the best of this can of worms, I'm going to adjourn the case. But presumably there's some imperative against adjourning these cases unnecessarily. It seemed right to everybody to continue.
Yeah, I mean, if the submission is that if the Secretary of State had little opportunity to grapple with the appellant's case,
Yes.
then she could have asked the tribunal for more time. She opposed the appellant's application. So instead of asking for more time, she considered those documents and made submissions. Why those documents were not.
Well, it doesn't seem. I mean, you can tell, at least on my part, that I have just difficulty with the general fairness of this whole process. I mean, what happens here is that you make an application in December 2012
Yes.
to become an entrepreneur,
Yes.
that you're refused in April 2015. And yet what we have here is a hearing that's been fixed in December 2015.
You said fixed on the 4th of November?
Fixed on the 4th of November.
Yes.
So you've, by that stage, had 4 or 5 months, April through to the beginning of November. So you've had 6 months and counting
Yes.
to produce evidence to show that your documents are correct. And we've narrowed down the fact that you wait until within 14, the client waits until 14 days of the hearing at best, and then produces letters.
Lord, the reason, I completely understand the point. The answer that I can put forward is this, that in this case, the burden of proof was on the Secretary of State. The appellant was perfectly entitled to wait and see what evidence comes from the Secretary of State. The Secretary of State files the respondent's bundle with the evidence.
Seems like a sort of Alice in Wonderland world where you have to establish that you've got money, and you produce something and you're told, I don't accept this, and then you wait and see why it's not accepted instead of just getting on and providing the evidence that might satisfy.
Well, the way in which the tribunal's rules are designed requires the respondent to file the bundle first.
I think you did tell us, when did the respondent's bundle have to be filed?
Within 28 days of the filing of the notice of appeal. I do not have the date on which it was filed.
Yes.
And the date of the application that was made, the appeal, that was lodged. I see. Appeal, the decision just says an appeal was launched.
Notice of appeal was 102nd.
Yes, thank you.
I'm not sure if we have the date on which.
No, I think that's the
I
second.
don't think we've got the first.
That's the second appeal.
The first
2nd
notice.
of November.
Well, that's
2nd November 2016.
But that's the
Yeah,
second.
that's the second.
Second refusal, so we don't have the first refusal.
No.
But presumably it takes some months between the time of filing the notice of application before you get a hearing.
Yes.
So, I mean, I understand if you say the system works like this, then the system works like this, but just trying to get my head around it, that you get a refusal in April, you launch an appeal without having to put up any case, you just complain.
Well, because
You then wait
yes,
and get the Secretary of State's documents, and then you put in documents within a few days of the hearing.
Lord, it's a fair, entirely fair point, but one has to look at it in the context that in the decision under appeal, the Secretary of State said absolutely nothing apart from saying that the bank document is false. So, is it?
I see the point. It's difficult to have obtained the 24th November letters which comment on the veracity of the email until you've seen the email.
Exactly. So, without knowing what the Secretary of State's case is, how is it, respectfully inviting lawyers to consider, the appellant was meant to submit evidence in the circumstances where the burden was on the Secretary of State. The appellant waited for the bundle to arrive. The respondent's bundle contained the relevant documentation. The appellant looked at those documents and then, as was required by the tribunal, adduced evidence addressing those documents.
So that if it's a funny system, your client isn't to be blamed for it.
No, Lord, yes.
I've written down that the system then was that within 28 days of the appeal, the Secretary of State had to serve her bundle.
That is still the system, yes.
That's still the system.
Yes.
And when I've written down within 28 days, that's the notice of appeal being received, is it?
That is correct, yes.
Which presumably has to be lodged within a specific time from the date of the decision.
That is correct, yes.
What's that? 28 days again?
Yes, 10 days. It was
10 days, all right.
10 working days, yeah, 2 weeks.
So, decision in April, notice of appeal would have to have been given, let's say, early May.
Yes.
Which means the Secretary of State would have had to have served her bundle sometime in June.
Yes.
All right.
We can proceed in that way. The system, the position now has changed in the sense that the appellant is required to file a bundle within 28 days of the receipt of the respondent's bundle, which gives a further gap between the date on which the appellant's bundle reaches the tribunal and the respondent and the actual date of the hearing. But that wasn't the position then. But my rather fundamental point is that the Secretary of State did not say that she had little or no opportunity to consider the evidence in the appellant's bundle to Judge Randall.
But in effect, we can work on the basis that she was aware of the Secretary of State's position, however valid or not it might have been, in about June. Assuming the rules had been complied with in this case.
Yes. If one assumes, yes, that would be an assumption. I mean, if everything was in order, then that would be the case. But then again, I respectfully invite my lord to consider this, that if the directions by the tribunal required the appellant to file the bundle 5 days before the hearing, why would she file a bundle, or why the solicitors would file a bundle months before the hearing?
But this has all got to do with the value judgment of what reasonable diligence requires for the Ladd-Marshall test, if one was applying.
I entirely agree, and the question is whether the Secretary of State had put forward any reasons as to why Ladd-Marshall test was met. What did she say to Judge White, or to Judge Francis, or to this court? Why this evidence could not have been adduced with reasonable diligence? It's not for me to say that the Secretary of State should have applied for an adjournment or should have asked for more time. If she was short of time, then it is for her to say to the court that, well, the presenting officer's unit in that week was busy. The presenting officer did not follow instructions. Come up with some explanation. But there is simply no explanation that is put either to this court or was put below as to why what the Secretary of State has done now could not have been done for the hearing before Judge Rendell. So I therefore submit that Laird and Marshall test is not met in this case. The judge did not apply the test, the correct test, and that is the submission that I make.
Yes.
Miller and Friend then made certain submissions as to the difference between the two decision letters, and Lords have already looked at the two decision letters. In both decision letters, the Secretary of State awarded points and relied on Rule 3221A. That is the focus of this appeal. There's a reference to Rule 245DD(h) of the immigration rules that, as I pointed out in my submissions earlier, provides a discretion to the Secretary of State to refuse an application, even if there are funds, all points are met, if the application is not genuine and the applicant is not a genuine entrepreneur. And Lord, I think that one fine point, there seems to be no dispute as to what this court should do if of course if my argument is accepted. The court will quash the decisions made below, which would mean that Judge Rendell's decision would stand, the Secretary of State would reconsider the matter. The Secretary of State would not be able to say that the bank statements submitted in 2012 were false, but she may ask the appellant about evidence of funds as things stand now. If the appellant provides any evidence, the Secretary of State may take that into account, grant that application. If there is no such evidence, the Secretary of State will refuse the application. So Lord, unless I can insist any further, these are the points that I wanted to make in reply.
I should have asked when you were making your first submissions. Your revised skeleton,
Yes.
Rehearses cause of action estoppel, and then there's the footnote saying effectively,
Yes.
accept this doesn't apply,
Yes.
reserve our decision.
Yes.
Are we in a position where we should simply ignore that as a factor in this case?
Yes, I said that because the Supreme Court last year, in a case called D.N. Ravanda, touched on this area and expressed doubts as to the correctness of this line of authority, and suggested that res judicata actually applies, but then it said that it won't decide the case, it won't decide the issue in that case. So I would simply reserve my position and entitlement.
It's settled at this level.
Yes, so I accept that res
Yes,
judicata does not.
so we
apply.
don't need to traverse it.
No.
Good.
But of course, if the court rules against me following all these authorities, then I simply reserve my position.
Understood.
Okay.
Well, thank you very much, Mr. Malik. Thank you to you and to Ms. Anderson and to those that have supported you. We'll reserve our judgments in this matter and let you have them in draft in the usual way. You're well familiar with the procedure, and once you've made the typographical corrections and so forth, we hope you'll be able to agree a draft order. Any submissions about that in writing, and the hand down will be take place one way or another, but without troubling you to attend.
Very grateful.
Thank you very much indeed.
All rise.
You were in D.N. Ravanda, isn't it? Yes, you were. Yeah.
Sorry.
I think if not in this appeal, then the Supreme Court will have to get over there with this